Calling page 8, case A-20-818973-C, Alfonso Noyola versus City of Boulder City.
Good morning, Mr. Barr. Good morning, Ms. Stout. And I do see that Mr. Hayes has joined us as well.
And Mr. Gordon has joined for
Yes, hi.
So,
Good morning, Mr. Gordon.
Good morning, Your Honor.
Good morning, Mr. Hayes. Who else do we have here? Anybody else? Okay. This is a defendant's motion for reconsideration of the order granting in part the attorney's fees, which this court certified as final pursuant to 54B. There was an opposition that was filed. The court notes that this matter has been appealed to the Supreme Court. Therefore, pursuant to Foster versus Dingwell, 126 Nevada 49, 2010, which was actually codified in March of 2019 as NRCP 62.1, this court only has the authority to either hold a hearing and deny the motion, or to certify its intent to grant the requested relief. I don't have the authority to simply grant the motion for reconsideration. That being said, the defendant notes in their motion for reconsideration that the court did include an analysis of the Smith versus Zilverberg decision in its order. Therefore, Smith versus Zilverberg was not something that this court did not consider. In fact, I would note that my prior firm was the attorneys that argued the Smith versus Zilverberg decision. So I'm highly aware of that decision. The problem with the Smith versus Zilverberg decision and what the court's inclination is at this juncture is the Smith versus Zilverberg decision, I think, is distinguishable from the case at bar. Specifically because there are still 3 claims for relief that are left open in this case. And what the Smith versus Zilverberg decision did not do, and I think left open, was the idea that if the entirety of the complaint is not dismissed, that you don't get the entirety of the attorney's fees from the inception of the case because there are still claims that are left. I don't know whether or not they're going to make that decision one way or another, but Smith versus Zilverberg got rid of the entirety of the case. And based on the other, and that's why when the court drafted the order on this case, the court very carefully looked at the other cases that held that that you only received attorney's fees and costs for the actual flat motion itself. And to the extent that Smith versus Zilverberg changes that analysis, it changes it from the perspective of the entirety of the case was gone. And I don't think that we have that same issue here. And I very specifically, in granting the attorney's fees in part, took a look at the actions that the court believes would have had to have been taken anyways on the basis of those other causes of action. And those are the ones that the court did not include in the award of attorney's fees and costs, setting aside the duplicative ones, but specifically there were things that the court found that it believed would have had to have been, regardless of whether or not causes 1 through 4 were dismissed or not, leaving the ones that are still here. So on that basis, the court wants some direction, quite frankly, from the Supreme Court as to whether or not, when you have a situation where the entirety of the complaint is not dismissed, that you don't award the full amount of the attorney's fees, but it only goes to the motion to dismiss itself. and the actions that are taken in relation to that. And so, therefore, since I can't grant the motion, would like some direction on this, and I think that it's important for everybody going forward. The court's intention in this matter is to deny the motion for reconsideration and leave it up to the Supreme Court to provide us with some direction. But I will allow you to make your record, Mr. Hayes. But that's the court's information.
Thank you, Your Honor. Again, Griff Hayes on behalf of the City of Boulder City. I respectfully, and I appreciate the court's comments on this issue and request for direction from the Supreme Court. I would submit the Supreme Court has already given direction. And if you look at footnote 8, Your Honor, and I'm sure you have, that's the footnote that references the differences between California and Nevada statutory law. And the Supreme Court specifically says that Nevada has no express legislative statement limiting the fees that a prevailing party on a SLAP motion can recover. So I think we have that direction. A few more points, Your Honor. There's no dispute as to the fees charged by the Bailey Kennedy firm. Your Honor has already ruled in the transcript those are reasonable. Your Honor has also ruled that with respect to the invoices submitted, that those invoices were adequate evidence of the work that was done and the time that was spent on the various tasks. Mr. Barr in the transcript agreed invoices would be good evidence of the work that was done. Certainly there was a disagreement as to what fees should be awarded, but there was no disagreement that the invoices would be evidence of the work that was done. The court also specifically noted that anti-SLAP motions are very difficult. The court also took no issue with the quality and ability of the Kennedy firm. As Your Honor knows, in the transcript, you made it very clear that you were not going to award any fees for anything other than the anti-SLAP motion. And in fact, Mr. Kennedy continued arguments in that regard. And Your Honor, for example, at the transcript, page 23, lines 15 through 21, let Mr. Kennedy know to the extent that he was focusing on anything other than the anti-SLAP. And this is when he started talking about the motions that were filed or the motion filed for preliminary injunction. Again, the court said, you need to move on because to the extent it's anything other than the anti-SLAP motion, I'm not going to grant that. And again, I would submit, Your Honor, that's absolutely inconsistent with the Smith case. It's absolutely inconsistent with what the Supreme Court has said in footnote 8 also. As Your Honor well knows, in the Smith versus Silverbrook case, the Nevada Supreme Court took great pains to point out the purpose of the statute of motions such as this nature. The purpose being filter out in unmeritorious claims and also to protect citizens from retaliatory lawsuits, which I would submit is exactly what we had here. And these protect them from lawsuits that are arising connection with their exercise of free speech. And again, the Supreme Court specifically identified as that a very important purpose in connection with the interpretation of the statute that it provided and the ruling that it came down with. Certainly, we respect, Your Honor. We note that during the hearing, you made a comment that there was a plethora of case law that says you just get fees related to the anti-SLAP motion. I would submit, Your Honor, again, as I said before, Smith addresses that. Footnote 8 specifically addresses that. We would respectfully disagree. Almost finished, Your Honor.
Take your time.
Thank you. Mr. Kennedy also referenced the statutory language 41.670, parentheses 1, parentheses A, where there's a mandatory statement about the court awarding reasonable attorney's fees to the person against whom the action is brought. Mr. Kennedy pointed out that we've got the City of Boulder City, we have Mayor McManus, we have Councilwoman Folda, and those three parties were the ones seeking the fees. And I also note that when Your Honor issued the award, there was a breakdown. I think the number was 152.15 hours in connection with work on behalf of the city and about 50.95 on behalf of the Mayor McManus and Councilwoman Folda. But in summary, for those reasons, Your Honor, we certainly understand the court's position, but would respectfully disagree. And this is an extremely unique situation where, again, no lawyers were aware of this. Certainly, it wasn't argued during the March 11th hearing. It was not briefed during the March 11th hearing. I became aware of it several days after the March 11th hearing and then reached out to opposing counsel. I would submit we have a situation where this is why there are motions for reconsideration. The parties did not have the benefit of that case. They didn't brief it, didn't argue it. But here, with the direction that we've got from the Supreme Court in the Smith case, and again, footnote 8 and the other points that I made, there is a strong basis, I would submit, Your Honor, to grant a motion for reconsideration and to award the, I think the number was approximately $230,682.37. That was the total attorney fee and cost reward requested by the Bailey Kennedy firm. Thank you, Your Honor.
Well, Mr. Hayes, let's start in reverse really quickly. Before you argue, Mr. Barr, let me address a couple of points made by Mr. Hayes. First of all, I can't grant the motion for reconsideration. Pursuant to NRCP 62.1, the most that I could do would be certify my intent to grant the motion for reconsideration. And that was based on the Foster v. Dingwell case, which was codified in March of 2019 in our new NRCP rules. So the most that I could do at this juncture would be to let the Supreme Court know of my intention to grant the motion, and then it would be up to them, then it would be up to you to file a motion for remand, to have it remanded back to me for me to grant the motion. To the extent that it's already up there, and I disagree that footnote 8 provides me with the analysis that I need. The Smith versus Zilverberg case got rid of the entirety of the case. That's not what's going on here. And to the extent that the motions for preliminary injunctions that were filed could go to the breach of contract claims that are at issue in this case, those are the ones that's why I said to Mr. Kennedy not to focus on those, because I think that those could also go to the breach of contract claims, which are still at issue. Additionally, as far as your argument that the court found that all of the costs were reasonable, not necessarily. The court did say that the ones that it awarded were reasonable, but it did specifically note that there were duplicative fees and inter-office conferences that it did not find to be reasonable. So based on that, Mr. Hayes, the court is going to stand by its original inclination. And I understand that you respectfully disagree with me, and that's the reason why ultimately, because here's the thing. I think we waste a whole bunch of judicial resources, because if I grant if I were to say, okay, my inclination is to grant your motion for reconsideration, then what ends up happening? So you file a motion for remand based on my intention to grant your motion for reconsideration, and one of two things happens. The Supreme Court says, no, we're not going to do that because we actually do think that this is an issue that we need to decide. And so they don't, because they don't rubber stamp it. There's case law that essentially says that if the court says that they have an intention to grant the motion, that they don't need to rubber stamp it. They can still say, no, we're going to hear this. Or they say, okay, we'll remand it back, and then Mr. Barr or Mr. Gordon turns around and refiles an appeal on the same issue. So because of that, that in and of itself is enough for me to deny your motion just on judicial economy, but also based on the analysis that I've set forth at the initial portion of this hearing, the court finds that the Smith versus Silverberg case is distinguishable and wants some direction from the Supreme Court on this. And I think it's an important issue for them to deal with.
Thank you, Your Honor. Just one very brief comment. When I referenced the issue about cost being reasonable, actually what I was talking about was the rates. There is no question, Your Honor, for example, eliminated some time, I think, related that the court viewed as duplicative. Also, interoffice conferences, that was related, was taken out of the calculation. The ultimate award, I certainly understand that. What I was referring to was the statement by the court in the record. For example, on page 21, lines 12 to 15, I'm not going to quibble about rates. The court felt that even though the rates were higher, that again, rates were reasonable under those circumstances. But thank you, Your Honor. I understand the court's ruling in this matter.
Thank you. Mr. Barr, Mr. Gordon, do you have anything that I saw you just nodding your head pretty much to everything I said, Mr. Barr, so I don't think that you have a lot to add, but if you do, feel free.
Thank you, Your Honor, for the thoughtful analysis. Jeff Barr on behalf of plaintiff Al Noyola, bar number 7269. I have nothing further to add other than to, again, thank the court for its thoughtful analysis.
Okay. Mr. Gordon, do you have anything to add?
Hello, Your Honor. Thank you. No. Hello, Your Honor. This is Richard Gordon, bar number 9036. I have nothing further to add either, other than to just let the court know that we'll be submitting shortly the stay order for the in light of the ruling here on this motion.
Okay. Ms. Stout, do you have anything to add?
No, Your Honor.
Okay. Mr. Barr, will you take the helm and do the order from this hearing, please?
Yes, Your Honor, of course.
Submit it to Mr. Hayes and Mr. Gordon and Stout for approval as to form and content.
Always.
Thank you very much. Anything else that the court can do for anybody this morning?
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Have a good day. Thank you.
Okay. Thank you.
I'm pulling up the exhibit. Give me 1 second here.
Sure.
Can you find me exhibit 7 and 8? I can't find it right now. Mr. Hayes, your response?
Yes, Your Honor.